Did you all get the memo? Boohoo Betty is very, very mad at us for stealing their videos. Let's have a listen to her. We've covered this before. Remember how this works? Every false claim is sprinkled with a little bit of truth. That's what makes it convincing.
So we protect our copyright. So, people are always going back here and say, it's on YouTube, I can use it. There's fair use. There's fair use, right? Oh my God, fair use. I'm sorry, running somebody's entire thing, presentation, their work on your YouTube page is against copyright.
Correct. Copying an entire video and uploading it is a copyright violation.
So since I've got to go and do the work for you to teach you, I'm not talking about you guys. I love you guys, but we know other people watch these things, right? And especially with that title, they're going to be very curious because I don't know what I'm talking about.
Yeah. Don't speak too soon, Boohoo Betty.
All right. Let's just get right into it. I'm so tired of talking about, right? So I went and pulled resources. I Googled it. Simple Google search will tell you everything you need to know, people. But acting dumb. You think Olivia spends, 20 hours to give 19 minutes for somebody to go make money off of it? Give me a break. It's against the rules. Even YouTube's rules. We're going to go over them.
Well, yes, we are. Except we're not going to rely on Google.
I keep getting all these people talking about, this copyright infringement. And somehow they think that just because it's put on Twitter or YouTube or social media, that it's up for anybody's grab. No, it's not. So let's get right into education, shall we?
Wonderful. Education sounds great. Let's do this thing.
Let's educate you guys a little bit, shall we? Let's do it. What's the definition of fair use? Right here. Let me read it for you, just in case it's too small for you to read. In U.S., so this is related to the U.S. copyright law, and that's important because I'm about to read something else from YouTube. The doctrine that brief excerpts of copyright material may, go to your Black Laws Dictionary, look up the word may, under certain circumstances, be quoted verbatim for purposes of such criticism, news reporting, teaching, and research without the need for permission from or payment to copyright holder.
Just between me and you, we're going to learn what this means very shortly.
So let's talk about YouTube. So YouTube, let me read this for the people that are blind or can't read. Fair use on YouTube. Fair use is a legal doctrine that says you can reuse copy-protected material under what? Oh, what is this? Certain circumstances. What? Without getting permission from the copyright owner. Fair use guidelines. Different countries have different rules. Why am I making why am I emphasizing that? Because as you just heard, in U.S. copyright laws, this is what fair use is.
It's the same in Australia, by the way, but shh, she's on a roll.
Let's go back to YouTube. So in different countries have different rules about when it's okay to use material without the copyright owner's permission. For example, in the United States, works of commentary, criticism, research, teaching, or news may, get your Black Laws Dictionary out and find out what may means, be considered fair use. Some other countries have similar concepts called fair dealing that may work differently. Courts look over potential fair use cases according to the facts of each specific case. You'll probably want to get legal advice. I would behoove you to get legal advice from experts before uploading videos that contain copyrighted material.
Okay, we'll see what a judge says then, shall we?
This is on YouTube's own website. 4 factors of fair use to consider. In the United States, judges decide what's considered fair use. A judge will consider how the 4 factors of fair use apply to each specific case. The 4 factors of fair use are: 1, the purpose and character of the use, including whether such use is of commercial nature, that means for profit, or for non-profit educational purposes. Let's try to do the drop down. Let's see what it says under the drop down. Does it have? Oh, so courts typically focus on whether the use of the copyrighted material was transformative. This means whether the use adds new expression or meaning to the original material, or whether it's merely copied from the original. I mean, we see that all the time. People just play the video, right? Commercial use are less likely to consider fair use, but it's still possible to monetize a video that contains fair use materials. Guys need to get your legal dictionaries out or get an attorney. The nature of copyrighted work. Using materials for primarily factual work is more likely to be fair use than using purely fictional work. Now, as you guys know, we create our own work. So, I'm sorry. That's ours. Borrowing small bits. Oh, what is this? So, amount and sustainability of portions used in relation to the copyright work as a whole. Borrowing small bits of material from an original work is more likely to be considered fair use than borrowing large portions. But if what's borrowed is considered the heart of the work, sometimes even a small sampling may weigh against fair use. Again, this is on YouTube's Help Center. So even small segments, small bits and pieces can violate copyright infringement. The effects of use upon the potential market for or value of the copyrighted work. Use that harms the copywriter's own ability to profit from their original work are less likely to be fair use. So when you take money out of the original, the creator's mouth, and profit off it, you don't have a leg to stand on under fair use. Are you listening to all this, trolls?
Yup. Now, let's hear how the balance is weighed in a real case. But first, a little warning.
Yeah, Gina, great point. Gina pointed out that if you do fight the complaint, then you have to turn over certain personal information about yourself, like where you live and your actual home address. And sometimes if somebody's trying to get that information from you anyway, they might even file a fraudulent or a fake copyright complaint in order to get your house information to do God knows what with that information. So it is very, very unsafe.
We already covered this in my last video. Do not give JLR or his crew your personal details.
So now let's go back to the court's analysis here. And the first thing that they are mentioning is a 4-step analysis. Now, if you've been to law school, if you've been to paralegal school, then you're probably very familiar with the 4-step copyright analysis. But if you haven't, don't worry, I got you. Hold on, here we go. Okay, so let's just read this. This is from copyright.gov, the official United States Copyright Office.
Not Google, although you could arrive at this website using Google.
And so let's see what they are going to tell us about these 4 parts of this test that we're going to have to run through. Now, we already know how this one turned out because the judges already decided on it. The opinion's already out there. But this is what the judges would have to do to go through any such claim like this, okay? So let's just read through what the United States Copyright Office says. Fair use is a legal doctrine that promotes freedom of expression by permitting the unlicensed use of copyright-protected works in certain circumstances. Section 107 of the Copyright Act provides the statutory framework for determining whether something is fair use and identifies certain types of uses. And those types of uses are criticism, commentary, news reporting, teaching or education, scholarship, and research as examples of activities that may qualify as fair use. Section 107 calls for consideration of the following 4 factors in evaluating a question of fair use, okay? So we have the United States Copyright Office kind of clarifying the law for us here. They're saying, look, fair use, this term fair use, everybody's talking about fair use this, fair use that. What that is, it's a legal doctrine. And what it does is promotes freedom of expression, right? So we have this idea in the United States, allegedly, apparently, that we are allowed to have opinions on things, even if they're unpopular, even if other people don't like those opinions, even if the opinions are wrong. We're allowed to express our wrong opinions still in 2022. Who knows what's going to happen as the years go on. But as of right now, the Constitution of the United States of America gives us all the right to have an opinion on some stuff, okay?
You see, copyright protects freedom of expression. It doesn't suppress it.
So the Constitution, the First Amendment, gives us the freedom of the press, gives us the freedom of expression, the freedom of association, and so it allows us, the Constitution of the United States is what gives us the freedom of expression. But then you have this copyright law, right? And that's kind of like, BTD, plucking on over. And it would look like the copyright law might contradict with the United States Constitution because basically the copyright laws sometimes can make it look like I'm not allowed to have an opinion on things because how am I gonna, play this clip to show people what it says in order to tell my opinion on it. It starts to kind of look like it might conflict. But if that ever happens, the person's freedom of expression and the constitutional right to freedom of expression has to trump, no pun intended, it has to trump any copyright, okay?
That's right. Your Constitution also protects freedom of expression.
So these are all the ways that I don't give 2.5 craps if you have a copyright or not. The statute, right, the Copyright Act itself, as well as the United States Constitution, tells us there's these loopholes where we are allowed to discuss and comment on copyrighted stuff, okay? These are the loopholes. If you're criticizing, if you're making commentary, if you're reporting on the news or a current event or an important public issue, right? Teaching or education, scholarship, and then research. Those are all examples of activities that are really supposed to be protecting you from a copyright claim or a lawsuit. Does that make sense? I hope that makes sense. Okay. So Section 107 calls for consideration of the following 4 factors. So that might sound familiar because remember the case brief mentioned the 4-step analysis. So we have to go through these 4 steps, and that's what the court did in Ethan's 2017 case.
These same 4 steps are listed on the YouTube website.
So what we are talking about today is YouTube videos, but you got to understand this could be anything. This could be anything, anywhere, anytime, anything on the internet, anything like that. Okay. And I assume that the reason that this person was particularly mad at the Kleins is because they have a monetized YouTube channel. And so they probably made money off of the commentary video.
Sounds familiar, right? Boohoo Betty is pretty mad about exactly the same thing.
So let's just kind of check back in on this case brief and see how the court weighed these 2 first factors in the Ethan Klein 2017 lawsuit. So the first factor in this one, which is the purpose and character of the infringing work, which we just discussed, it weighed heavily in the Klein's favor because their video is quintessential criticism, and comment. And as we discussed at the beginning part of this video, that is protected by the Constitution. There's no copyright law that can come and take away your fundamental rights that are given to you by the Constitution, especially the Bill of Rights, those first 10 amendments. You cannot overcome that with copyright law. You just can't. And so, since we still do have the freedom of expression given to us by the Constitution, it weighed heavily in Ethan and Gila's favor. Okay, so the second factor, the nature of the copyrighted work, remember we just saw that, we just discussed it on the other page, favored Matt, because his work was in fact entirely scripted and fictional. So see how it says here, it's gonna matter whether it's some kind of movie or song, something fictional, versus something that's like factual that somebody could probably have found out on their own, given enough research. You know what I mean? So so the first one went in favor of Ethan and Gila. The second one went in favor of Matt. And so right now we have an even balance, right? One for the plaintiff, one for the defendant. So let's move to the third one and see how we are gonna progress. Okay. Amount and substantiality. I don't know why that's always a hard word for me to pronounce. Amount and substantiality of the portion used in relation to the copyrighted work as a whole. So this is going to be, we'll read it, but this is, more like if it's a whole entire movie, you only use 14 seconds. That's not a lot. But if it's a whole entire 3-hour movie and you put up on your channel 2.5 hours of the 3 hours, then that's a lot of the movie, right? If it's a excerpt from a book that's just a sentence or two, that's not a lot, right? But if it's several chapters and you've published it and stuff like that, that might be a lot. So this one, amount and substantiality of the portion used in relation to the copyrighted work as a whole. So let's see what the court in the Klein case actually determined was going on. The third factor, amount and substantiality of the portion used, was neutral. Well, would you look at that? Bet y'all didn't know you could have a neutral. So how do we weigh that in our test? That's kind of confusing, right? The court said it was neutral. So they didn't rule in favor of Ethan or Matt. They just left it there as it was. Let's see if we can get to their reasoning as to why that was. They said to comment on and critique a work, clips of the original may be used. So listen, and this is what I wanted to make this video for. This is the bottom line on YouTube. So creators using copyrighted materials to do reaction videos is completely protected under the United States Constitution, as well as the Section 107 of the United States Copyright Act.
Are you learning anything from this lawyer, Boohoo Betty?
Because you are able, right, to comment on and critique a work, clips of the original may be used. And their use of the clips, that's Ethan, use of the clips was obviously necessary and reasonable to accomplish the transformative purpose of the critical commentary. Look at this. This is kind of confusing, right? We're in the transformative purpose here, but transformative is something that we've talked about in the first factor. So why are we talking about it again on the third factor? And it's really not actually that confusing. It's just something that you continue to balance throughout the entire test. So they're saying, look, how could Ethan possibly and Gila possibly have done any transformation of the clip if they didn't use the clip? So Ethan and Gila actually commenting on the clip, talking about the clip, talking over the clip, pausing the clip to talk about it and stuff like that was considered to be transformative. Remember I told you all kind of stuff can be transformative and all kind of things can be transformation. This is one of the things that can be. If you're using a clip and you stop it, you're talking over it, you're laughing, you're making fun of it, you're pausing it and putting minutes and minutes and minutes of commentary between the clip, you can totally do that. And this court is actually agreeing with me that you can do that 4 years ago. It was totally reasonable. And it was actually even necessary for them to be able to comment on the video that they showed clips of the video. But they did go ahead and admit at the same time, it was a great deal of plaintiff's work that was copied. So they did say it was neutral. Here's our analysis. Ethan needed to do it, but it was a whole lot. So for that purpose, we're just not going to we're going to strike number 3. Let's see if we can get to number 4 as the tiebreaker. Because remember, the first factor weighed in favor of Ethan and Hilla. The second factor weighed on the scale in favor of Matt. The third factor was a tie. Nobody got the favor on that one. So let's see if we can break the tie with factor 4. The final factor, okay, is called effect of the use upon the potential market or value of the copyrighted works. So in assessing this factor, this effect, the market effect factor, that's the fourth one, courts consider whether the use is hurting the current market for the original work. For example, by displacing sales of the original, and or whether the use could cause substantial harm if it were to become widespread. So it doesn't actually have to be widespread. It just has to be, look, if this person's channel went viral, would they no longer be able to make money off of this because now the other person's widespread use is just rampant and everybody's just stealing their stuff? So let's see how the court ruled on that factor. I mean, I imagine it's for Ethan because he won. The final factor, effect of the use upon the potential market, weighed in favor of Ethan. Why? Because their video does not serve as a market substitute for plaintiff's video because it responds to and transforms the plaintiff's video from a skit into fodder for commentary and mockery. So basically, this was the transformation. The court determined that it was transformative because it transformed the video from just a skit that you could go and watch into fodder for commentary and mockery. Accordingly, the court found the use was fair. And I agree, Sean Cat, nobody is going to commentary channels for pristine clips they can watch or listen to. That's ignorant, and that's why these suits are frivolous. And I think the court agreed with you.
So there you have it, folks. Boohoo Betty hasn't got a leg to stand on so long as you follow the rules that this lawyer has just outlined for you. You can watch the full video from that Surprise Witness TV, and the link is in the description.